Hello, my dear law students. This video is intended for you to create a very good memorial for our moot court competition. So again, our moot court competition deals with the case of Victims Against International Occupation or VIO versus Executive Secretary. If you remember, I have sent you a copy of this sample for the format of our memorial. So this is the first page or the cover page. It will be followed by the table of contents, the index of authorities, the statement of jurisdiction, the questions presented or the issues in the record, the statement of facts, and the summary of pleadings. In this lesson, I will be discussing to you the statement of facts and the summary of pleadings for both the applicant and the respondent. Here is a statement of facts of the applicant. Remember that when you are the applicant, make sure that the statement of facts must be on your favor. There are actually different styles on how to write the statement of facts, but make sure that you follow the general rule that the statement of facts must be readily understandable. Petitioner victims of international occupation or VIO filed a petition for writ of certiorari and prohibition with the Supreme Court en banc against the Executive Secretary, alleging that the treaty is unconstitutional and derogates Philippine sovereignty. VIO also filed a petition for writ of mandamus with the Supreme Court to order the DFA and the Office of the President to release the requested information, alleging that it does not fall under any of the exceptions and, in case of doubt regarding the classification, Article 2, Section 28 of the Constitution should be construed in favor of the release of information. The Executive Secretary, on the other hand, contend that there is nothing illegal in the treaty since what was only given is a right to occupy the existing artificial islands. These islands are not even Philippine territory under the PCA ruling since these are ruled to be not islands. Further, the country is bound by the principle of pacta sunt servanda for having signed and ratified the treaty. If you notice, however, these are actually general facts and not very much favorable to the respondent. Therefore, you have to find ways in order for your statement of facts to be favorable to your side. Lastly, the denial of the request for information on the ground that it falls squarely under the exceptions already provided for under the law and the jurisprudence. This is now how you are going to present the issue. Is the West Philippine Sea or South China Sea Treaty constitutional? And are there legal grounds to require the release of the requested information? Class, remember that I will be presenting to you only the summary of pleadings for the applicant and later for the respondent. This summary is very general. Now, it is your duty to expand the summary of pleadings, research on the legal basis, the provisions of law, and the cases applicable under the summary of pleadings. Do not be limited with the summary of pleadings that I will be presenting to you. Again, you are free to expand whatever is presented right before you in this video. You have to always look at the issue of the case. Is the West Philippine Sea or South China Sea Treaty constitutional? If you are the applicant, you will always say that it is not constitutional. The second question is, are there legal grounds to require the release of the requested information? Then you have to answer yes, since you are the applicant requesting for the release of the information during the negotiation. Now, the first pleading is that the Supreme Court has jurisdiction to take cognizance of the instant petition. Second, the West Philippine Sea and South China Sea Treaty is unconstitutional, and that the continuing refusal of the government to disclose the contents of the West Philippine Sea and the South China Sea Treaty violates the constitutional provisions on transparency and the right to information on matters of public concern. Now, let us expand number 1, number 2, and number 3. Under number 1, again, the Supreme Court has jurisdiction to take cognizance of the instant petition. Why is that? The instant petition for certiorari and prohibition is proper because the President gravely abused his discretion in entering into a treaty jeopardizing the country's territorial integrity and sovereignty. The attendant circumstances constitute an exception to the principle of hierarchy of courts, which justify the exercise of Supreme Court's primary jurisdiction over instant petition. The case involves constitutional issues of transcendental importance. The elements of judicial review are complied with, which are petitioners have legal standing to institute the instant suit and that the case poses a justiciable controversy. Lastly, the present controversy does not constitute a political question. Guys, you may follow this line up. However, it is already your duty to expand on these different claims when we talk about the jurisdiction of the Supreme Court to take cognizance of the instant case. Second one, that the West Philippine Sea and South China Sea Treaty is unconstitutional based on the following grounds. That the treaty disregarded the arbitral ruling which is not consistent with our constitution and national interest, and B, the treaty contravenes the Philippine Constitution as it constitutes an abdication of Philippine sovereignty. The third pleading talks about the continuing refusal of the government to disclose the contents of the West Philippine Sea and the South China Sea Treaty violates the constitutional provision on transparency and the right to information on matters of public concern. Why is that? First, the public right to information is a fundamental right enshrined and guaranteed by the Constitution. The West Philippine Sea and the South China Sea Treaty is a matter of vital public concern and interest to the entire Filipino nation because it will impact the country's territorial integrity and sovereignty. Third, the refusal of the government to disclose the offers made prior to the conclusion of the treaty violates the constitutional right of the Filipino people to effective and reasonable participation in all levels of social, political, and economic decision-making. The right to information is essential for the Filipino people to exercise their constitutional right to participate effectively. Fourth, the executive secretary cannot validly claim executive privilege since the privilege was not invoked by order of the president. Letter E, the office of the president has failed to show that the petitioners are not entitled to the information and documents required. And lastly, the information and documents being requested do not fall under the exceptions to the general rule on public disclosure that would justify denial of access to them. Class, gihungit na nako sa inyo ha. All you have to do is to expand the summary. Let us now go to the statement of the facts of the respondents. Okay, this is like actually almost the same with the petitioner, but make sure that you write something that is favorable to the respondent. See, Vayo also filed a petition for writ of mandamus with the Supreme Court to order the DFA and the Office of the President to release the requested information, alleging that it does not fall under any of the exceptions, and in case of doubt regarding the classification, Article 2, Section 28 of the Constitution should be construed in favor of the release of the information. Again, these are just general facts, so make sure that you make a statement of facts favorable to your side. Summary of pleadings for the respondent. We have 3. First, the Supreme Court has no jurisdiction to take cognizance of the instant case. Remember, guys, that appearing before the Supreme Court, questioning its jurisdiction is not actually acceptance of its jurisdiction. You are there because you question the jurisdiction of the Supreme Court. Number 2, the West Philippine Sea and the South China Sea Treaty is constitutional, of course, because you are the government. The continuing refusal of the government to disclose the contents of the West Philippine Sea and the South China Sea Treaty does not violate the constitutional provisions on transparency and the right to information on matters of public concern. Let us expand now numbers 1, 2, and 3. Number 1, the Supreme Court has no jurisdiction. Why? The instant petition for certiorari and prohibition is not proper because the President did not gravely abuse his discretion in entering into a treaty which does not affect the country's territorial integrity and sovereignty. Letter B, the attendant circumstances do not constitute an exception to the principle of hierarchy of courts, which justifies the exercise of the Supreme Court's primary jurisdiction over the instant petition. That this case does not involve constitutional issues of transcendental importance, that the elements of judicial review are not complied with. What are those? And the present controversy constitutes a political question. If you notice, this is just a counter-argument of the applicant. How about when we say that the West Philippine Sea or the South China Sea is constitutional based on the following grounds? That the treaty does not disregard the arbitral ruling but merely constitutes an exercise of self-restraint over activities that would complicate or escalate disputes and affect peace and stability. Letter B, the treaty does not contravene the Philippine Constitution as it does not constitute an abdication of Philippine sovereignty. The islands in the disputed waters do not form part of the Philippine territory. And the treaty is already valid and binding if it contravenes. And that letter C, the treaty is already valid and binding even if it contravenes the provisions of the Philippine law. Number 3, let us expand. The continuing refusal of the government to disclose the contents of the WP and the SCS treaty does not violate the constitutional provisions on transparency and the right to information on matters of public concern. Is it right that the government refused the publication of the negotiation of the treaty? The government said that the WP and SC treaty is covered by the doctrine of executive privilege. Hence, the same is not subject to full disclosure to the public. And lastly, the petitioners have not shown sufficient public need that would overcome the doctrine of executive privilege. Now, all you have to do, guys, is to research. Remember that you already have your Constitutional Law 1. These are basic facts. All you have to do is to substantiate the summary of pleadings. You look for constitutional provisions and cases that would particularly apply in the case. Remember, choose only landmark cases. And if you cannot find any case applicable to this one, you always look at international sources, publications, but always remember the hierarchy of sources. Thank you very much, guys, and I hope that you're going to make a very good memorial for our moot court competition.